Aereo, the streaming service that networks killed in court. In the golden age of cord cutting, when Netflix was disrupting television and consumers were desperately seeking alternatives to expensive cable packages, a scrappy startup called Aereo emerged with what seemed like the perfect solution. Founded in 2012 by former IAC executive Chet Kanogia, Aereo promised to liberate broadcast television from the shackles of traditional cable companies by capturing over-the-air signals with tiny antennas and streaming them to subscribers' devices. The concept was brilliantly simple. Since broadcast networks transmitted their signals freely through the airwaves, and anyone could legally capture these signals with an antenna, why couldn't a company do this at scale and stream the content to paying customers? Aereo's revolutionary approach involved installing thousands of dime-sized antennas in warehouses across major metropolitan areas, with each subscriber assigned their own individual antenna and DVR storage space. This technical architecture was deliberately designed to mirror what a consumer could legally do at home with a traditional antenna and recording device, just relocated to a remote facility with better reception and cloud-based convenience. The service launched in New York City for $8 per month, offering access to major broadcast networks like ABC, CBS, NBC, and Fox, along with the ability to record shows and watch them later on smartphones, tablets, computers, or streaming devices. Within months, Aereo had attracted over 100,000 subscribers and raised $60 million in funding from high-profile investors, including Barry Diller's IAC and media mogul David Geffen, who saw the potential to fundamentally reshape how Americans consumed television content. The broadcast network's reaction to Aereo was swift and apocalyptic. CBS CEO Les Moonves called it stealing our signal, while Disney's Bob Iger described it as copyright infringement wrapped in technological innovation. The network's fury wasn't just about lost subscription fees from cable companies, though those retransmission fees had grown into a multi-billion-dollar revenue stream by 2012. More fundamentally, Aereo threatened the entire ecosystem of television economics that had developed over decades. Cable and satellite companies paid networks hundreds of millions annually for the right to retransmit broadcast signals, money that funded everything from local news operations to primetime scripted series. If Aereo's model proved legal, it could open the floodgates for similar services that might eventually eliminate retransmission fees entirely, while also providing detailed viewer data that had traditionally belonged to the networks. The legal challenge began just 3 months after Aereo's launch, when a coalition of broadcasters including ABC, CBS, NBC, Fox, PBS, and Univision filed a federal lawsuit in Manhattan seeking an immediate injunction to shut down the service. Their argument centered on the claim that Aereo was engaged in massive copyright infringement by retransmitting their copyrighted programming without permission or compensation, regardless of the technical method used to capture the signals. The networks also argued that Aereo was essentially operating as a cable company without paying the same licensing fees and regulatory obligations that traditional multi-channel video programming distributors faced under federal communications law. Aereo's legal defense rested on a sophisticated understanding of copyright precedent, particularly the Supreme Court's 2008 decision in Cartoon Network versus CSC Holdings, which established that individual copies of copyrighted works stored for individual users could qualify for different treatment under copyright law than public performances. The company's founders and their legal team, led by prominent copyright attorney David Hosp, argued that their antenna and storage architecture created individual private performances for each subscriber rather than a single public performance for all users simultaneously. Each subscriber was assigned a dedicated antenna no larger than a dime, and when they chose to watch a program, their specific antenna would capture the broadcast signal and their individual copy would be created and stored on their designated hard drive space before being transmitted to their device. This technical setup, Aereo contended, was legally indistinguishable from a consumer installing their own antenna on Aereo's roof and running a very long cable back to their apartment, with the cloud-based storage functioning like a personal DVR. The company also emphasized that it was not selecting or curating content, but simply providing access to the same free broadcast signals that were already available to anyone with an antenna in the coverage area. Furthermore, Aereo argued that their service actually benefited broadcasters by extending the reach of over-the-air signals to viewers who might otherwise be unable to receive them due to geographic or architectural obstacles, potentially increasing the audience for advertiser-supported programming. The initial legal battles produced mixed results that kept both sides fighting and Aereo expanding. Federal District Judge Allison Nathan denied the broadcaster's request for a preliminary injunction in July 2012, ruling that Aereo's system created individual rather than public performances and therefore did not violate copyright law. Judge Nathan's decision relied heavily on the technical architecture of Aereo's system, noting that each subscriber was assigned a unique antenna and that no content was transmitted until a specific user made a specific request for a specific program. The ruling allowed Aereo to continue operating and emboldened the company to expand beyond New York City into markets including Boston, Atlanta, Miami, Houston, and Dallas throughout 2013. However, the legal landscape remained treacherous, as different federal courts reached contradictory conclusions about similar services. The Second Circuit Court of Appeals upheld Judge Nathan's decision in April 2013, but courts in other jurisdictions were less sympathetic to the antenna-based streaming model. A federal court in Los Angeles issued an injunction against Film on X, a similar service, finding that it constituted copyright infringement regardless of its technical implementation. This split in federal court decisions made it virtually certain that the Supreme Court would eventually need to resolve the conflict, while Aereo continued to grow its subscriber base and expand into new markets with the knowledge that its entire business model remained legally precarious. The Supreme Court's decision to hear the case in January 2014 marked the beginning of the end for Aereo, though the company continued to project confidence and expand its service offerings. The case, formally titled American Broadcasting Companies vs. Aereo, attracted enormous attention from technology companies, content creators, consumer advocacy groups, and legal scholars who recognized that the decision could reshape the boundaries between traditional broadcasting and internet-based streaming services. Major technology companies including Google, Microsoft, and Amazon filed amicus briefs supporting Aereo, arguing that an overly broad ruling against the service could threaten cloud computing services that store and transmit users' personal files. The brief filed by these tech giants warned that if Aereo's individual antenna system constituted a public performance under copyright law, then cloud storage services that allowed users to access their own music, video, and document files from remote servers could face similar legal challenges. Meanwhile, content creators from Hollywood studios to independent filmmakers rallied behind the broadcast networks, arguing that Aereo's business model threatened the fundamental economics of content creation by allowing companies to retransmit copyrighted programming without paying licensing fees. The Obama administration also weighed in against Aereo, with Solicitor General Donald Verrilli arguing that the service was clearly engaged in public performance of copyrighted works regardless of its technical architecture. The Supreme Court oral arguments on April 22, 2014 revealed deep skepticism from multiple justices about Aereo's technical arguments and business model. Justice Stephen Breyer, who would ultimately write the majority opinion, pressed Aereo's attorney David Frederick about why the company's service should be treated differently from cable television systems, which were required to pay retransmission fees under copyright law. Justice Breyer noted that from the consumer's perspective, Aereo functioned exactly like a cable company, delivering television programming to subscribers for a monthly fee, regardless of the technical method used to capture and transmit the signals. Justice Anthony Kennedy questioned whether Aereo's individual antenna system was merely a technological gimmick designed to circumvent copyright law rather than a meaningful technical distinction that should affect legal analysis. Even justices who were generally sympathetic to technology companies expressed concern about the broader implications of Aereo's legal theory. Justice Elena Kagan wondered whether Aereo's logic could allow any company to retransmit copyrighted content without permission, as long as they used individual antennas or storage systems, potentially undermining the entire licensing framework that supported content creation. The broadcast network's attorney Paul Clement argued forcefully that Aereo was simply a cable company trying to avoid paying the same licensing fees that every other distributor of broadcast content was required to pay under federal law. The Supreme Court's decision on June 25, 2014, was devastating for Aereo and unambiguous in its reasoning. In a 6-3 ruling authored by Justice Breyer, the court held that Aereo's service constituted a public performance of copyrighted works under the Copyright Act, regardless of the technical method used to capture and transmit broadcast signals. The majority opinion focused on the functional similarity between Aereo and traditional cable companies rather than the technical differences that form the core of Aereo's legal defense. Justice Breyer wrote that Aereo was not merely providing equipment that consumers use to access broadcast television, but was actively performing copyrighted works by transmitting specific programs to subscribers at specific times when they chose to watch. The court noted that Congress had specifically amended copyright law in 1976 to ensure that cable companies paid licensing fees for retransmitting broadcast signals, and allowing Aereo to provide the same service without the same obligations would undermine this congressional intent. The majority opinion also rejected Aereo's argument that assigning individual antennas to subscribers created private rather than public performances, noting that the aggregate effect of the service was to transmit the same programs to large numbers of subscribers simultaneously. Justice Breyer emphasized that the decision was narrowly focused on services that retransmit broadcast television programming and should not affect cloud computing services that store and transmit users' personal files. The three dissenting justices, led by Justice Antonin Scalia, argued that the majority had improperly focused on Aereo's business model rather than the specific legal question of whether the service created public performances under copyright law. Justice Scalia's dissent warned that the majority's functional approach to copyright analysis could create uncertainty for technology companies developing new cloud-based services, since courts would now need to evaluate not just the technical operation of these services, but also their business purpose and market effect. The dissent argued that Aereo's system genuinely created individual copies and individual transmissions for each subscriber, which should qualify as private performances regardless of the aggregate business model. Justice Scalia also criticized the majority for relying on congressional intent from 1976 copyright amendments rather than applying the specific language of current copyright law to Aereo's novel technology. However, the dissenting justices acknowledged that their interpretation could potentially allow other companies to develop similar services that might compete with traditional broadcasters without paying licensing fees, a prospect that concerned even some technology advocates who had supported Aereo's legal position. Within hours of the Supreme Court decision, Aereo announced that it was suspending service to its subscribers and evaluating its options for continuing operations. CEO Chet Kanogia released a statement calling the decision a massive setback for the American consumer and predicting that it would stifle innovation in the television industry. The company had been hemorrhaging money throughout the legal battle, spending millions on attorneys' fees while being unable to expand freely or negotiate content licensing deals due to the uncertain legal environment. Aereo briefly attempted to reinvent itself as a traditional cable company that would pay retransmission fees to broadcast networks, but this approach proved financially impossible given the company's subscriber base and pricing structure. The broadcast networks, still furious about Aereo's original business model, refused to negotiate licensing agreements on terms that would have allowed the company to remain viable. Cable programming networks also declined to license their content to Aereo, viewing the company as a threat to the broader multi-channel television ecosystem. By November 2014, just 5 months after the Supreme Court decision, Aereo filed for bankruptcy and began the process of liquidating its assets. The company's failure left over 700,000 subscribers without service and resulted in complete losses for investors who had contributed more than $97 million to fund the venture. The death of Aereo marked a decisive victory for traditional broadcast networks in their fight against technology-enabled cord cutting, but also highlighted the growing tension between legacy media companies and innovative streaming services. The Supreme Court decision effectively created a legal firewall protecting the retransmission fee revenue that had become crucial to broadcast network economics, ensuring that any company wanting to redistribute broadcast signals would need to negotiate licensing agreements or face copyright infringement claims. However, the broader trend towards streaming and cord cutting continued accelerating after Aereo's demise, with services like Netflix, Hulu, and Amazon Prime Video gaining millions of subscribers and eventually launching their own live television offerings with proper licensing agreements. The broadcast network's victory over Aereo proved Pyrrhic in many ways, as traditional television viewership continued declining and advertising revenue shifted toward digital platforms that offered better targeting and measurement capabilities. Several former Aereo executives, including founder Chet Kanogia, went on to launch new technology ventures focused on wireless internet and streaming services, though none attempted to recreate Aereo's specific approach to broadcast television. The company's story became a cautionary tale about the limits of technological innovation when confronting established legal frameworks, demonstrating that even the most clever technical architecture cannot overcome copyright law and entrenched industry opposition. Today, more than a decade after Aereo's launch, the television industry has evolved towards streaming-first distribution models that accomplish many of the same consumer benefits that Aereo promised, but through negotiated licensing agreements rather than legal loopholes and technical workarounds.